supplementary cause list, item number 1 for pronouncement of judgment.
You are there.
I'm just appearing for Mr. Bidem as he's out of station. Just asked me to appear on his behalf for the petitioner.
I'll read out only the operative portion. In the light of the above findings and observation, this court is of the view that the approach of the respondent authorities as far as the case of the petitioner is concerned is not correct, and the same has caused prejudice to his case of entitlement for grant of ACP, MACP at the relevant period, as well as an arbitrary reduction of his pay also at the relevant period of time. The same is hereby corrected herein by a direction to the respondent authorities to embark on a course correction and to ensure that the petitioner is not deprived of his legally entitled dues and benefits, whether in respect of the grant of ACP, MACP, or a proper pay scale. This exercise is to be carried out within a period of 4 months from the date of receipt of this order. Consequently, the impugned orders dated so-and-so and order dated so-and-so, to the extent it affects the petitioner, are hereby set aside and quashed. Petition is disposed of, there shall be no order as to cause. Yes.
I would like to make a mention of item 25, my lord. I have some difficulty today. It is taken up any other day.
Yes.
My lord, the respondent they are supposed to file the written argument, my lord. I have filed.
You have filed.
I have filed, my lord.
That also I'll file before the next day.
Do it.
My lord.
How long?
My lord, 2 weeks.
2 weeks. On prayer made by the respondent, State of Meghalaya, matters adjourned. List is same after 2 weeks.
Obliged.
Obliged.
Yeah, please, Your Lordship, I beg to mention item number 16. As Mr. SD is on sanction leave, is not keeping it. Let this matter come after 2 weeks.
2017 matter.
He is on sanction leave, Your Lordship.
Who's for the petitioner? Any objection?
No objection.
On prayer made by the respondent. 1, 2, and 3 not objected to by the petitioner. Matters adjourned. List is after 2 weeks.
May we please, Your Lordship? Your Lordship, I beg to mention item number 29. Your Lordship, I beg to seek 3 weeks' time, Your Lordship.
You're for?
The petitioner, Your Lordship.
For the respondent.
Any objection?
No questions, Your Lordship.
On prayer made by the petitioner. List is matter to 3 weeks.
Highly obliged, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 31. Your Lordship, we pray for 3 weeks' time in this matter as the learned DSGI is on sanctioned leave. Your Lordship, prior consent has been taken from them.
Who's for the respondent?
Your Lordship, Mr. S. Panti.
Have you sought his consent?
Yes, Your Lordship.
Yeah. Yes, Mr. Panji.
Lordship. In fact, the counsel from Delhi also, they were appearing through VC, Lordship.
On prayer made by the petitioner, not objected to by respondent. List is matter to 3 weeks.
Much appreciated.
Obliged.
Your Lordship, similar prayer for item number 14.
What?
Your Lordship, prior consent has been
You are for?
for respondents, Your Lordship.
Who's for the petitioner?
Your Lordship, Mr. Sir Asu. Lordship,
Have you
by
sought their
consent.
consent?
Yes, Lordship.
2016 matter. On pre-made by the respondent. Not objected to by respondent, by petitioner. This is matter up to 1 week.
Much obliged.
May please, Lordship. Lordship, I beg to mention item number 11. Lordship, the Connaught Council is currently out of station, Lordship, and he'll be returning next week, Lordship. Lordship, may I have it next week? We can.
Your Lordship, senior counsel is on VC.
Yes, Mr. Mishra? Can you hear us? Can't hear you. You have to on your microphone. Put on your microphone.
Am I audible now?
Yes, you are. So a judgment has been...
So what I'm saying is, it's more than 10 months since I argued the matter, and completely argued. So what I propose, my lord, subject to what my learned friend says, just 1 day before the hearing or 2 days before the hearing, I will submit a list of dates which will recap, my lord, what I had argued. Just list of dates in very short. And then your lordship hear them. After that, when my turn comes to reply, if your lordship desires, I will repeat the answer.
Fine. That you can do.
Right.
How long?
Then we will give list of dates.
Lordship,
How long?
2 weeks, Lordship.
2 weeks. On prey made by the respondent. Not objected to by petitioner. List is matter up to 2 weeks.
Your Lordship, if date may be fixed.
What date do you want?
Convenience of senior counsel.
Yes, Mr. Mishra, any date? Yes, sought for 2 weeks' time.
Since I am submitting a list of dates, the local lawyer of Shillong would be there. So it is his convenience and they have to start the argument.
Fine. Fine. So 2 weeks' time.
So they can choose.
Thank you.
Obliged.
May I please, Your Lordship, I beg to mention item 28, Your Lordship. I pray this matter will come up after 1 week, Your Lordship.
28.
28, Your Lordship.
On prey made by the appellant, list is matter up to 3 weeks.
Deeply.
Highly obliged.
May it please Your Lordship, I beg to mention item number 12, my lord.
12.
Yes, my lord.
Any news?
No, my lord, nothing.
But you said it has been taken up?
It was taken up. We have filed another mention memo also, my lord. So
No, the matter was not heard.
no. It just prayed. They prayed for time and the matter adjourned.
On prey made by the parties, this is matter after 4 weeks.
Much obliged, my lord. My lord, similar prayer for item.
You try and try to get it expedited.
Definitely, my lord. That's why
because it is your case.
our interest is at stake. So we are pressurizing. Its appeal is there, my lord. They are seeking time, my lord.
Well,
So I will.
you can't help it. We are not in control of the other court.
Definitely, my lord. I am not blaming this, my lord.
But you have to keep it in mind, it's a 2015 matter.
My lord.
Thank you.
Similar prayer for item number 27 as well, my lord.
You hear, Mr. Jha?
Yes, my lord. My lord, it is. They have to seek instructions on that. With regards to that medical premature, the date was
Okay. Oh, okay.
premature.
That could have been settled, decided. What is there?
My lord,
You have
it may
made a
come up-
mistake.
It may come next week, my lord.
On prey made by the respondent, not objected to by petitioner, this is matter up to 1 week.
Much obliged.
Hello, please.
May it please your Lordship. Lordship, I beg to make a mention of item number 19. Lordship, I'm praying if this matter may be listed next week. Conducting counsel is out of station.
I think this court has made it clear that these old matters cannot be adjourned at the on the drop of a hat.
Sure.
Time and again you have sought for apparently no reasons at all. If the conducting counsel is not available, somebody else should come. Please ensure that it's taken up.
Lordship.
On prayer made by the petitioner, list this matter after 1 week.
Lordship, a similar prayer for item 26.
On prayer made by petitioner, list this matter after 2 weeks.
Highly obliged, Lordship. 26.
Lordship, I beg to mention item number 17, Lordship. If the matter can come up next week, my Lord, I will inform the counsel for the petitioner, Mr. Sangreso. Today I am having some difficulty, Lordship. So
You are just to file your written argument, isn't it?
no, my Lord, the hearing
But
has
has not
not
been heard.
started in this case.
2017 matter.
17. After 2 weeks, my Lord.
On prayer made by the state respondent, matter is adjourned. Not objected to by petitioner, matter is adjourned. List the same after 2 weeks.
Highly obliged, my Lord.
But ensure that
Yes, my Lord. Today, due to some difficulty.
because if you don't, pursue the matter diligently, then
Absolutely.
nothing can be done. Finally, the court just have to, I will have to look at only the available papers and
Pass
pass the orders.
Absolutely. Obliged.
Supplement request is item number 2.
Yes, Mr. Not
Firstly, I'm sorry, my lord, that I have to wear this. I have undergone surgery.
surgery.
Cataract surgery.
You can't
No,
look at papers.
I cannot give the stage, but I can. Now it is already 2 weeks now.
It is simple. It's a simple issue.
It's a simple issue. I think Mr. Kenta is appearing. Here, my lord, some prayers which were in connection with the election of the CM of Milli, and that part is over. in view of the
election being concluded.
Yes, but we have some other prayers, my lord, and we are challenging the suspension and revocation of the suspension order of the earlier CM, who is under the
But you cannot club all the prayers together, Mr. Nath. If your primary prayer is per se against the election process, that has become infructuous.
My lord, we have first and second prayer, my lord.
Petition. I think there is a similar petition filed with regard to these two issues
By some other,
some other party.
petitioners.
So
That one, I think, has withdrawn yesterday, I think.
what has been withdrawn?
Yes, that has been withdrawn. But our contention is, my lord, is survived because of the challenge of the suspension order and its resignation order, and it is acceptance of resignation, while the concerned person is under the inquiry in regard to the misappropriation of the organization's fund, my lord.
Who are the respondents here?
District Council, Mr. Kinta is appearing.
Only District Council?
Yes.
Yes, Mr. Kanta, anything?
Your Lordship, the writ petition is they are challenging three actions of the respondents. Number one, they are challenging the election process. So far, election process has become infructuous. The election has been conducted and accepted by the House. If they want to move, they have got an alternative remedy. And insofar the other prayer is concerned, that is the prayer the prayer relating to recall the acceptance of the resignation tendered by Sri Lathom Maniksem. The point here, Your Lordship, there is another writ petition on a similar course of action that has already been withdrawn by some other parties. Now the point here, Your Lordship, is that what is the locus of the writ petitioner? They are neither holding any post in the steamship, neither they are the electors, and they are not even the complainants, Your Lordship. The complainants are the ministries, where the ministries.
The issue of
now their inquiry is still.
Mr. Kanta, the issue of maintainability will be looked into.
Yes, Your Lordship.
Mr. Nath, I think in the area of parties,
yes,
you should have also included the.
My lord, I'll pray for a little amendment also, my lord.
You have to amend and include Mr. Lathomanik same as the respondent.
Yes, my lord. And plus the other portion which has become is partly infructuous, my lord. That part will be omitted, my lord. I'll pray for.
Otherwise, you withdraw this petition and file a fresh one.
Or my lord,
I think they have that option.
Or I'll file
the can be given.
Yes. What do you say?
Yes, my lord, it's all the same. And
I have no objection. Let it be withdrawn. Let them file afresh. I have no objection to that.
Heard Mr. H.R. Nath, Learned Counsel for the Petitioner. Also heard Mr. B.J.K. Kanta, Learned Senior Counsel, appearing as Special Counsel for the Respondent KHADC. Mr. Nar has submitted that this petition will be allowed to be withdrawn with liberty to file a fresh one. On premier, the same is allowed. Petition is accordingly dismissed as withdrawn. Liberty sought for allowed.
Much obliged.
Yes.
Okay.
Lady first list, item number 1.
My lord, this was an application for continuation of delay. The respondent has filed a show cause to this fixed for hearing.
Your Honor, on the last date, your junior counsel had appeared and he has stated that he will file an objection with regards to the show cause that we have filed.
No, my lord. I don't think so. There can be any objection for that. We had filed a petition for.
You have filed, they have filed a show cause.
Yes, yes.
So we'll hear.
Yes, it can be heard now.
On the issue of condonation.
It can be heard.
Let the matter be fixed for another 2 weeks' time, Your Honor, as our senior counsel is not able to take up the matter today, Your Honor.
Who's leading?
1 week's time, Your
Who's leading this case?
Mansoori.
Mr. M.N. Mansoori.
On premier by the respondent. This is matter for 2 weeks.
Item number 2.
Lordship, in this case, petitioners filed one additional affidavit. So let me have
That is in response to your affidavit.
No, this it is additional affidavit separately, Your Lordship. They've given one reply and another additional affidavit, Your Lordship.
Yes, yes, yes.
So,
only mentioning about the jurisdiction of the village
Yes, yes.
court and subordinate district council.
That could have been taken up, at the hearing. You could have raised this issue at the hearing.
Yes, Lordship.
But why have you filed?
Let him file.
So, Your Lordship, I need some instruction because new matters come up, and I should inform you, Lordship.
A matter of law.
But still, I should inform you, Lordship. And in this case, Mr. Khaini was there, the advocate, one of them. So I have to take instruction from him. I didn't get him.
How long?
A little bit after 3 weeks.
After 3 weeks, no, Lordship, after 1 week.
1 week
There is
good.
nothing to
1 week is good.
take instruction about law.
It's a revision petition. In revision, the scope of interference is very limited.
I have.
So we'll have to look into that aspect of the matter. Nothing much. No facts involved. So one week?
On 25th of this month, Lordship. After 1 week. Calendar to roll as well. Data na.
25th, Mr. Nar? Devnar? On prayer made by Mr. Devnar, learned counsel for the respondent, not objected to by the petitioner. This matter is now posted for hearing. List the same on 25th March.
25th. No.
So 25th.
All right. Okay.
Item number 3.
Three, four, five. Yes. What do you want?
May it please, Lordship. Lordship, my senior is currently immersed in some other part-heard matter before court too. So I pray that your Lordship may accommodate some time.
Oh, you see, firstly, we have to, I think it is put up today for the report on the notice, if I'm not mistaken. You have taken steps for issue of notice? Or you'll be there?
Yes.
482.
482, Your Lordship, yes. Quashing of the FIR and the proceeding and all.
In this case, there are two inquiry reports. One inquiry was conducted that DC West Government has constituted a committee. Thereafter, another inquiry was conducted by the Lokaita Lordship. So parallel to inquiry, and both the inquiry found that yes, misappropriated the funds.
Okay, misappropriation.
Connecting that matter, the 7 writ petitions are pending before this honorable court because the allegations were made by the teachers' lordship. When they put up the allegation, then all the teachers were terminated, and all the teachers' petitions pending before this honorable court. And now he has.
What is the stage of the case?
Lordship, charge-sheeted, and most of they are facing trial, Your Lordship.
Any evidence recorded?
Lordship, I'm not sure because there was an order. They got the
case
order
is still
from here.
pending
Issue
before
one
the
of
trial court, ma'am. Case is still pending before the trial court.
Pending, yes, but at what stage? Mr. S.A. Sheikh, Learned Counsel has entered appearance on behalf of the respondent 4. Have you filed your power, Mr. Sheikh?
Yes.
And has made a prayer that this matter may be heard on the next date. As prayed for, list this matter after 2 weeks.
2 weeks. 3, 4, 5, Your Lordship.
3, 4, 5 are connected matters.
Same order.
Apply, Your Lordship.
Apply.
Item number 6.
My affidavit is ready. I'll try to file it in the course of the day.
You have just produced one notification and it has taken you for so long.
My lord, because I had to not take initiative on my own because Paraby's comment as such was nothing, my lord.
Have you filed your counter? You are not required.
because it's the state, the notification is passed by the state. So for us, it's
So the fight is basically between the state and the petitioner.
the fight is between the state.
Mr. K.P. Bhattacharjee, Learned GA, has submitted that the counter affidavit may be allowed to be filed in course of the day. Let the same be filed with copies to all the parties concerned. As prayed for, this is matter to 2 weeks.
Item number 7.
Your Lordship, I am appearing for petitioner in this matter, Your Lordship.
Yes, miss, what is required?
Lordship, we had to file affidavit of service for notice issued to respondent number 4, but due to some defect, it could not be filed. So maybe 1 week may be granted.
Miss, the office note says that the notice has returned unserved, or rather unclaimed.
Sorry, Your Lordship.
I said the office note says that the notice has returned unserved.
Yes, Your Lordship.
Unserved and unclaimed.
Fresh steps.
So you have to take fresh steps.
But in my record, Your Lordship. Okay, Your Lordship.
If you have a record which says that the notice has been affected, then you file the affidavit of service.
Yes.
Or you take fresh steps, that is up to you. Learned counsel for the petitioner has submitted that the affidavit of service as regard the notice, acceptance of notice by the respondent 4 may be allowed to be filed before this court. And in the alternative, if the same could not be obtained, then fresh steps may be allowed to be taken. Pray aloud. This is matter up to 3 weeks.
Item number 9.
Petitioner, what is this case about?
Demotion from service from the post of headmaster, Lordship.
So you start.
Lordship, as per the last order, the respondent number 4 and 5, they are supposed to file the counter affidavit, Lordship. This is a newly constituted.
Since the previous council already filed an affidavit, see the record, check the record, so will not file any affidavit.
Okay. Not. You will depend. You will rely on the affidavit already filed.
And for the queries of this, bring one aspect The petitioner is no more in the service, no more in the school. So matter
No in the school.
He is no longer in the school. Long time back, he left the school.
Then, Lordship, I'll have to take instruction on that.
Okay. Because basically your petition is with regard to demotion.
Lordship.
But if you are no longer in service, then indeed it has become infructuous. You seek instruction.
I'll take instruction, Lordship.
1 week.
2 weeks, Lordship.
Then a counsel for the petitioner has been submitted. It has been submitted by the learned counsel appearing for respondent 4 and 5 that the petitioner is no longer in service in the school, in the concerned school. However, the learned counsel for the petitioner has submitted that instructions in this regard may be allowed to be sought for and to apprise this court of the same on the next date fix. As prayed for, this is matter after 2 weeks.
Highly obliged, Lordship.
Item number 18.
All the respondents are here.
Lordship.
Lordship, hearing was part heard already. It was already part heard, Lordship, and then due to some when we were going through the agreement, Lordship, that was published in the Gazette Meghalaya, it was not readable. So they have the petitioners, they have come forward with the typed copy, which was not provided in the writ petition initially. So later on they have come up with the typed copy, and Lordship,
yes.
Since now the typed copy is now the typed copy is available with Lordship, then we can proceed with the matter, Lordship.
Yes, we'll proceed with the matter.
Yes, Lordship. And
Lordship, I'd just like to bring your Lordship's attention to one small. Lordship, as per section 14B of the Employment Provident Fund Act 1952, Section 14B, your Lordship.
Yes.
Lordship, I may be allowed to read, your Lordship. Lordship, where an employer makes default in the payment of any contribution to the fund, pension fund, or insurance fund, or in the transfer of accumulations required to be transferred by him under section 2 of section 15 or subsection 5 of section 17, or in the payment of any of the charges payable under any other provisions of this act or scheme or insurance scheme, or under any of the conditions specified under section 17. The Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover. Your Lordship, I'd like to stress on this that the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damages not exceeding the amount of areas as may be specified in the scheme. Now, Your Lordship, the impugned order has been passed by the Assistant Provident Fund Commissioner. So now, Lordship, my question is, Your Lordship, is he authorized as per section 14B? If not, then this whole proceeding stands vitiated.
Have you made such pleadings in your petition?
Your Lordship,
No, Lordship.
not because Your Lordship, it is in the Act itself, section
Yes, could be, but
14B.
you could have made a mention that you see, because primarily your case will depend on the.
Your Lordship,
on
this
the
is one of
notification-
the points.
on the defect of the notification.
This is just one of the points.
Yes, that will be considered in due course. So, Mr. Tawa, just refresh this code on what has been submitted earlier.
Yes, Your Lordship. Your Lordship, the respondent number 3 had issued the impugned order, annexure 10, page 42, Your Lordship. Whereby the respondent number 3 had found that the petitioners were liable to pay the damages as calculated by the respondent number 3 as per the impugned order. And thereafter, Your Lordship, the impugned notice of demand, annexure 11, page 46, was issued. Now, Your Lordship, the petitioner company is a limestone mining company,
Yes.
which was established way back in the year 1973, Your Lordship. And it was set up, Lordship, after there was a joint survey study between the government of India as well as the government of Bangladesh. And the petitioner company was set up specifically to export limestone to Chatak Cement Company, a Bangladesh-based company, via ropeway, Your Lordship. That was the main reason due to which the petitioner company was established. And, Your Lordship, the petitioners then were given a mining lease of 20 years, which was subsequently renewed, Your Lordship. And, Your Lordship, the petitioner company is a 50-50% equity shareholder with the government of Meghalaya, which basically means that it is a government establishment. Now, Your Lordship, initially, Your Lordship,
where does it says that it is a government establishment?
Your Lordship, it's not a government establishment, but it is a 50-50% with the equity partnership with the government of Meghalaya in para 3, Your Lordship, page 7. Now, Your Lordship, then in the year 2003, via notification in the Gazette, the petitioner company was exempted
Yes.
from the provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1952.
Yes.
This this exemption, as per the notification, was with effect from 1st of June 1976.
Yes.
So, Your Lordship,
Where is
since
the notification?
Annexure 2, Your Lordship, page 28. This is the copy which my learned friend was saying that a typed copy had been.
Okay. Yes.
Now, Your Lordship, the notification, Your Lordship states, Your Lordship, the first page before the third paragraph. Now, therefore, in exercise of the powers conferred by Clause A of subsection 1 of Section 17 of the said Act,
Yes.
subjected to the conditions in the schedule annexed hereto, the state government hereby exempts the said establishment from the operation of all of the provisions of the said scheme with effect from 1st June 1976.
Yes.
It has said that exempted from all of the provisions, Your Lordship. Now, Your Lordship, thereafter, Your Lordship, the Provident Fund was the Provident Fund organization was nowhere in the picture. Your Lordship, then in the year in the year 2009, Lordship,
Yes.
the petitioners received a letter dated 25/3/2009,
Yes.
which is at Annexure 3, Your Lordship.
Page?
Page 31, Your Lordship. They received a letter to show cause as to why the exemption under Section 17(1)(a) of the 1952 Act should not be withdrawn. Now, Your Lordship, Section 14 I'm sorry, Section Section 17, Your Lordship. Section 17, subsection 4. Of the EPF and MP Act 1952.
Section
17, subsection 4. States, Your Lordship, I may be allowed to read. Any exemption granted under this section may be cancelled by the authority which granted it.
Yes.
By order in writing.
Yes.
If the employer fails to comply, so. Now, Your Lordship, it says that the exemption can be cancelled only by the authority which granted it, and that also in writing. And, Your Lordship, this exemption was given by the government of Meghalaya, not the Provident Fund organization. Now, Your Lordship, but the Provident Fund organization had issued a notice to the petitioner company to show cause as to why the exemption should not be withdrawn. And thereafter, Your Lordship, Annexure 5, page 35. Page 36 is the typed copy, Your Lordship. Letter dated 10/6/2014 was issued.
Page 36.
Page 36, which is the typed copy, Your Lordship. Whereby it states that since the establishment, just read you. So, with reference to the subject cited above, I would like to inform you that since you are not a complying establishment, and according to cancel the relaxation, you are requested to submit the resolution passed by the trustees regarding cancellation of relaxation, and you are also requested to pay transfer and to transfer the past accumulation immediately. Now, Your Lordship, this letter, the subject itself states cancellation of the exemption under under section 17(1) of the EPF Act. Your Lordship, in the rejoinder, filed by the petitioners, Lordship, Annexure 6, page 12.
Annexure 6.
Page 12 of the rejoinder.
Whose rejoinder?
Of
Your rejoinder?
Our rejoinder.
Page?
Page 12, Your Lordship. Last page.
Page 6.
Page 12, Your Lordship. Annexure 6. Lordship, here the subject is surrendering of the trust fund of the Comoro Limestone Staff Provident Fund vis-a-vis cancellation of exemption under section 17(1)(a). Reference is Sir, with reference to our letter cited above, you are hereby directed to comply with the provisions of the scheme through code number AS 829 with effect from 1/4/2014 as an unexempted establishment. Now, Your Lordship, the respondent, the Provident Fund organization, had by themselves declared that the petitioner company's exemption has been cancelled. That was the impression they had been given all through to the petitioners, where in fact they did not have the power under section 17 subsection 4. Now, Your Lordship, that however subsequently a notification has been issued by the state government cancelling the exemption, which is dated 28th November 2019, which is under challenge in the writ petition which was in the order stage earlier, Your Lordship, item 6. So now, Your Lordship, even though the Provident Fund organization did not have the power, still they kept on sending letters and notices to the petitioner company as if the exemption granted to them had been cancelled with effect from 1/4/2014. Now, since the petitioner company did not know of this provision and did not know that the Provident Fund organization does not have the power to cancel the exemption, they started complying with whatever the Provident Fund organization told them to do. So, Your Lordship, in the process, a lot of funds were even transferred to the Provident Fund organization. And in fact, most of the fund were transferred, and there's only a few past accumulations which are there, and some money which have been invested in certain bonds which are still with the company. Now, Your Lordship, taking advantage of this, the respondent Provident Fund organization, Your Lordship, initiated proceedings under section 14B. Under section 14.
Yes.
Which deals with penalties. Now, taking advantage of that, Your Lordship, they kept on sending, and then ultimately the Provident Fund organization initiated proceedings under section 14B of the EPF Act
for recovery
of the penalties imposed, because, Your Lordship, what had happened was there was some lapse due to for the transfer. So that those lapses, they imposed penalties on those lapses, and they proceeded with the proceedings under section 14B. Which is power to recover damages, which is the section which I had read initially before I started my submission, Your Lordship, which clearly states that it is the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf. Regarding this section, Your Lordship, 14b, who has the power to recover? Now, Your Lordship, if Your Lordship goes to Annexure 10, page 42,
Annexure 10 of your
writ petition, mean writ petition.
Yes.
Your Lordship, it clearly states it is dated 25/2016 before the Assistant Provident Fund Commissioner, who is the respondent number 3 here in the instant writ petition, Your Lordship.
Yes.
That is the point which I wanted to, whether the respondent number 3 has the authority
Yes.
to proceed under section 14b without a specific notification in this behalf.
Yes.
And Your Lordship, Annexure 10, page 42 itself, Your Lordship, the last part,
Yes.
Your Lordship, Srimati M.C. Sanglan appeared again on so-and-so for hearing. She was explained the following. Exemption was withdrawn with effect from 4/2014. Your Lordship, this is what they have done. They have misled the petitioner company into believing that the exemption has been cancelled, withdrawn, since the year 2014, month of April. Whereas, in fact, the exemption has been withdrawn only on 20th November 2019. They have misled the petitioner company into believing that the exemption was cancelled.
Yes.
And now, Your Lordship, due to this, they have imposed the penalties for the lapse of payment.
Yes.
And they have even given notice of demand for recovery of the said penalties, which was issued by the recovery officer, who is the respondent number 4 herein. And this is also the impugned, Your Lordship, in the instant writ.
Where is the notice?
The Annexure 11, page 46, Your Lordship.
Yes. You have already referred to this.
Yes, these are the impugned. Annexure 10 and 11 are the impugned. Now, Lordship, what has happened is, due to the fact that the petitioner company had been misled into believing that their exemption had been cancelled, they started transferring money to the Provident Fund organization. And in the meanwhile, Your Lordship, what had happened was that the Deputy Secretary to the Government of Meghalaya, by letter dated 28/7/2016, Annexure 8, Your Lordship, page 40, Your Lordship.
Yes.
This was sent by the Deputy Secretary to the Government of Meghalaya to the Regional Provident Fund Commissioner. The respondent number 2, Your Lordship. This is regarding notification on the official gazette Government of Meghalaya for cancellation of grant of exemption on Comora Limestone Staff Provident Fund and surrender of exemption to the Employees Provident Fund Organization. Your Lordship, it states, with reference to the subject cited above, I am directed to request you to submit a copy of the letter accepting the representation submitted by the staff of Comora Limestone Mining Company to enable the department to take further necessary action. Your Lordship, Annexure 9, page 41, next page, Your Lordship. It is a reminder. This is from the Secretary to the Government of Meghalaya.
Yes.
To the respondent number 2. Your Lordship, the subject is the same. And reference has been made to Annexure 8. Now, Your Lordship, here, with reference to the letter on the subject cited above, I am directed to say that till date no reply has been received from your end. You are therefore requested to expedite immediately furnishing a copy of the letter accepting the representation submitted by the staff of KLMC to enable the department to take further necessary action. The government came into the picture when, Your Lordship, this is also addressed to the respondent number 2. And a copy was sent to the petitioner. Now, Your Lordship, when the Provident Fund organization realized that the petitioner company have come to realize that they don't have the power to cancel the exemption, then they approach the state government to take necessary action. And the state government, by Annexure 8 and 9, had directed the respondent number 2 to furnish the copy of the letter accepting the representation submitted by the staff of KLMC. This is because, Your Lordship, the Provident Fund organization is an organization which is meant to be for the benefit of the employees. Now, Your Lordship, in fact,
before you continue, Mr. Thaga,
yes,
how many employees do you have in your unit?
At present, Your Lordship.
At the relevant point of time?
At that relevant point of time, the exact number I don't have with me right now.
You should have your records ready.
But quite a few, Your Lordship, several hundred, more than around 200-300 people.
So you have crossed that
yes,
mark of 20.
Yes.
Is it 20?
Yes, they have
50.
crossed the, they have crossed the mark. No, 20. It's 20. They have crossed the mark.
It is, we have crossed that mark.
Please continue.
Now, Lordship, what has happened, Lordship, is the petitioner company at present, Your Lordship, has been suspended from all operations by the IBM, Indian Bureau of Mines. That is another subject matter. And it is going to be 3 years. But however, Your Lordship, when the impugned order and notice was issued, which was in the year 2016, Your Lordship, then it was functioning. Now, Your Lordship, due to the actions of the Provident Fund organizations, the employees of the petitioner's company have been suffering for quite a long time, Your Lordship. Why, Your Lordship? Because they are not receiving any benefits, Your Lordship. Till date, Your Lordship, they are not receiving any benefits. There are several employees who have even died, Your Lordship. Their services have ended, in fact, they have passed away, but still they have not received any benefit till
You have
date.
not received benefit in what sense? Firstly, was any contribution
Yes, Your Lordship.
collected from them?
Yes.
Have you also equally contributed?
Yes.
So, in effect, it is it is in compliance with the relevant rules.
Yes.
Or act.
Yes, because we were misled, but to believe that the exemption was cancelled. Thereafter, Your Lordship, we started transferring the funds. In spite of that, none of the employees have benefited. Not even one employee, Your Lordship. The EPF organization, the Provident Fund organization, they are very fast in imposing penalties due to lapse of contribution of the employers, the petitioners. But from their part, they have done nothing. So that, because the main purpose why the EPF organization came into existence was for the benefit of the employees.
Exactly.
But here, Your Lordship, the employees are suffering. They are not benefiting.
In what sense they are not benefiting?
They haven't received anything from the Provident Fund. Neither can they avail. The present employees, Your Lordship, I am speaking about the year 2016, because this is a writ petition filed in the year 2017.
What are the schemes of thing on the utilization of the funds? If the fund have been collected, deposited with the EPF organization, certain benefits have to be given to the employees.
Yes.
In what form? Was it in terms in the way of loans? Was it in the way of final payment to them, or
they have received nothing, Your Lordship? They have there are several employees who have retired. They haven't received their final dues which they were supposed to get from the EPF.
You can answer that. Not now, but your turn comes.
During the thing, nor could the employees avail any loan on the basis of the Provident Fund thing. They could do nothing, Your Lordship. And, Your Lordship, the petitioner company was in hanging, Your Lordship. It was neither here, neither there. It is all because of the fact that the respondent Provident Fund organization, Your Lordship, misled the petitioner company into believing that their exemption had been withdrawn with effect from April 2014.
Okay.
Prior to that, Your Lordship, everything was taken care by the petitioner company itself.
So you have your own scheme, or what do you do?
Initially, Your Lordship, yes, there's a trust which takes care of all the benefits which the employees should get. But initially, benefits were given to the employees. They could avail even loan, everything, Your Lordship. Because the EPF is, when there's any, when the benefits are at par or better than the ones provided by the Provident Fund organization, then the companies can. That was what was happening. But after, Your Lordship, this all started in the year 2009 when they started giving letter regarding the cancellation of exemption. And thereafter, Your Lordship, funds were transferred, accumulations were given, but there were some past accumulations which could not be given because they were in the form of bonds and which could not be broken. Otherwise, we would face even more loss. Now, Your Lordship, even the Provident Fund organization, the respondents 2, 3, and 4, in their affidavit, have admitted the fact that, Your Lordship, a lot of funds had been deposited with them. And in their affidavit, Your Lordship, Annexure E.
Annexure
E. Page. There's no paging, Your Lordship. Annexure E. Your Lordship.
affidavit dated?
Pardon you.
Affidavit dated what?
Affidavit dated 29th August 2017. Filed by the EPF organization, Your Lordship.
Annexure
E, Your Lordship.
E.
Yes.
What does this say?
Your Lordship, here regarding surrendering of trust fund of KLMC staff provident fund vis-a-vis cancellation of exemption. With reference to our letter cited above, you are hereby directed to comply with the provisions of the scheme through quote so and so with effect from 1/4/2014 as an unexempted establishment. Your Lordship, this is what I was saying about that they misled us. The Board of Trust is also directed to prepare past accumulation in prescribed form as on 31/3/2014 with the up-to-date interest credited on each member account and submit the same along with the other auditor's report as on the date of surrendering the exemption within 15 days under section 17(1)(a) within 15 days received, failing which further legal action under section 7(a), section 7(q) and section 14(b) of the Act will be initiated against you. And thereafter, Your Lordship, the Annexure B are the accumulations which were given.
Annexure B is your deposit?
Yes, Your Lordship. Annexure B and there are several deposits which were made, which were kept account by the respondent. Now, Your Lordship, since we were led to believe that the exemption had been cancelled since the year 2014, Lordship, the then managing director of the petitioner company had written a letter, Annexure 6, page 37 of the writ petition, Your Lordship.
Page?
Page 37, Your Lordship.
Yes.
Surrendering of trust fund of KLMC staff provident fund vis cancellation of exemption. Lordship, then next page, Your Lordship, page 38. Even the Board of Trustees, in its meeting held on 14/3/2014,
Yes.
had passed a resolution that surrendering of provident fund to RPFC Shillong, page 38, Your Lordship. The board was informed that due to difficulty in maintaining pattern of investment as per provisions due to non-availability of bonds so and so, resulting in high rate of premium and lesser rate of. In respect of the pattern of investment, Lordship, the next paragraph.
Yes.
Resolved that KLMC Staff Provident Fund, which was exempted under Section 17(1)(a) of the EPF Act 1952, by notification so and so, would like to surrender the entire trust fund to Regional Provident Fund Commissioner with immediate effect. Now that after that, Your Lordship, they started depositing, and even the respondent EPF organization have admitted to that fact, Your Lordship.
Yes.
Now, Your Lordship, the question arises that because this is an this is a writ challenging Annexure 10 and 11. Now, Lordship, the question arises, the first is that whether, as I pointed out earlier, the respondent number 3 has the authority to proceed under Section 14B. Lordship, even if so, Your Lordship, then another question arises is that when the exemption had not been cancelled by the appropriate authority, which is the state government, respondent number 1, the actions of the EPF organization into in misleading the petitioner company into believing that the exemption had been cancelled since 2014, whether it's proper, and when the actual cancellation of the exemption occurred by notification dated 28th November 2019. Could the respondent number 3 and respondent number 4 issue the impugned orders Annexure 10 and impugned notice of demand Annexure 11? And Lordship, now the fact of the case is that the notification as on the date when the penalties were imposed was in force. So, could the petitioner, could the respondent Provident Fund organization impose penalty when the exemption was still going on? And could the recovery officer issue the notice of demand, which is the impugned notice? I'm not sure why I have raised all this is because the respondent petitioner, respondent 2, 3 and 4 in their rejoinder have again and again relied on section 14, section 17, sorry Lordship, section 17.
Yes.
Subsection 1A.
Yes.
Which states that section 17 subsection 1 1A, your lordship, 1 capital A.
Capital A.
Yes, your lordship.
Yes, transfer of accounts.
No, your lordship. Section 17 1.
Oh, section 17(1).
Yes. Power to exempt, and then your lordship, because we were exempted under section 17 1A, and below that, your lordship, there's a proviso, and then there is 1A. Did you get your
Yes, yes. 1 is here.
Where an exemption has been granted to an establishment under clause E of subsection 1, the provisions of section 6, 7A, 8 and 14B shall, so far as may be, apply to the employer of the exempted establishment in addition to such other conditions as may be specified in the notification granting such exemption, and where such employer contravenes or makes default in complying with any of the said provision or any of the provisions of this act, he shall be punishable under section as if the said establishment has not been exempted under clause E. Now, your lordship, the action of the respondent Provident Fund organization since the year 2009, which is Annexure 3, which I had read earlier. Your lordship, the actions of the Provident Fund organization since the year 2009, as per Annexure 3, page 31, which I had uh, pointed out earlier, is the notice to show cause as to why exemption under section 17(1)(a) should not be withdrawn. Since the year 2009, the Provident Fund organization has with malified intention has kept on pressurizing the petitioner company into believing that they have the authority who have the power to exempt. So their action has led into all these complications, and due to which, Your Lordship, the employees were the ones who suffered ultimately.
You've said that time and again.
Yes, Your Lordship. And so, if that be the case, Your Lordship, then whether section 17(1) capital A, which the Provident Fund organization has been Your Lordship, have been relying on in their rejoinder, can that be accepted? And also the fact that since the notification was, since the actual exemption was cancelled in the year 2019, could the proceedings under 14B be taken up in the year 2016? So, Your Lordship, my contention is that since they cannot, so Your Lordship, the impugned order, Annexure 10, as well as the impugned notice, Annexure 11, Your Lordship, are liable to be set aside.
Yes, who will reply?
Lordship, at the outset only, I would like to bring your kind attention on the prayer, Lordship. What they are saying is that we do not have power, Lordship. Lordship, in the prayer of the writ petition, they have never prayed that we are not the adjudicating authority. If that is so, Lordship,
I think the objection against you is mostly, on the point that section 14, whether you are authorized or not, or who is the authorized person.
Yes, Lordship.
To issue the notice.
Yes. So in the prayer, they have neither in the writ petition nor in the prayer, they have stated that we are not the not the adjudicating authority or not the person who can pass this order. Competent authority who can pass the order. Lordship, if that is the case, Lordship, in section 7I, Lordship, it's the appeal to the tribunal, Lordship. If they are saying that we are not, we do not have that power, they can opt for appeal, Lordship, which is provided in section 7I.
Yes.
Appeal to tribunal. Any person aggrieved by notification issued by the central government or an order passed by the central government or any authority under the provision of subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of 7A or section 7B, except an order rejecting an application for review referred to in subsection 5 thereof or section 7C or section 14B, may prefer an appeal to a tribunal against such notification or order. Every appeal under subsection 1 shall be filed in such form and manner within such time and may be accompanied by such fees as may be prescribed, Lordship. So, they have an option to go for appeal if they are saying that we are not the competent authority to pass this order. Lordship, now if we come to notification, Lordship. Notification, it is not an exempted as it is not an exemption in general. It comes with clauses, Lordship. The clauses are mentioned in the schedule. There are various clauses. In detail, Lordship, I won't
Where's the notification?
Notification which they have given in the typed copy.
Annexure 2.
Annexure 2 of the writ petition, the typed copy, Lordship.
Yes.
Lordship, it comes with all the clauses, Lordship. Specific clauses are, Lordship, 6, clause number 6, clause number 8. Lordship, whether shall I go through? Lordship. Clause number 6. Where an employer who is already a member of the employee's provident fund, statutory, or a provident fund of any other exempted establishment is employed in his establishment, the employer shall immediately enroll him as the member of the fund and arrange to have the accumulation in the provident fund account of such employees with his previous employee transferred and credited to his account. It comes with clauses, Lordship. Now, clause 8, provident fund shall vest in the bond of trustees who will be responsible for and accountable to the employees provident fund organization inter alia for proper accounts of the receipts into and payments of the provident fund and the balances in their custody. Lordship, I am reading the important clauses, Lordship. Now, Lordship, clause number 13, Lordship. The Board of Trustees shall invest the monies in the fund as per direction that may be given by the central government from time to time. The securities shall be obtained in the name of the Board of Trustees and shall be kept in the custody of a scheduled bank under the control of the Reserve Bank of India. Failure to make an investment as per direction of government shall make the Board of Trustees severally and jointly liable to surcharge as may be imposed by the Central Provident Fund Commissioner or his representative. Point number 16. Board of Trustees shall maintain detailed account to show the contribution, credit, withdrawal and interest in respect of such employees. Then comes, Lordship, point number 22. The employer as well as the Board of Trustees shall submit such return to the Regional Provident Fund Commissioner as the central government or Central Provident Fund Commissioner as may prescribe from time to time. If the Provident Fund rules of the establishment provide for forfeiture of the employee's contribution in cases where an employee ceases to be a member of the fund on the lines of para 69 of the said scheme, the Board of Trustees shall maintain a separate account of the accounts so forfeit and may utilize the same for such purpose as may be determined with the prior approval of the Central Provident Fund Commissioner. Point number 24. Notwithstanding anything contained in the rule of the Provident Fund of the establishment, if the account payable to any member, amount payable to any member upon his ceasing to be an employee of the establishment or transferable on his transfer to any other establishment by way of employer, and employee's contribution plus interest thereon taken together with the amount. If any payable under the gratuity or pension rules be less than the amount that would be payable as employers and employees' contribution plus interest thereon. If he were a member of the Provident Fund under the said scheme, the employer shall pay the difference to the member of a compensation to the member as compensation or special contribution. 25. The employer shall bear all the expenses of the administration of the Provident Fund, including the maintenance of account, submission of returns, transfers of accumulation. This is, in nutshell, Lordship, the notification under which the clauses are there. Lordship, now if we come to Lordship, now if we come to the writ petition, Annexure 3, page 31. Lordship, second paragraph.
Yes.
Lordship, second paragraph. Whereas your trust is enjoying exemption under section. Lordship, you are in the page?
Yes,
May I
yes.
start?
Please,
Yes.
please.
Whereas your trust is enjoying exemption under section 17(1)(a) of the EPF and MP Act 1952, the records available in this office and the observation raised by the Compliance Audit Inspection Team Wide Inspection Report dated 24/09/2008. 2008. May I repeat? Inspection report dated 24/09/2008 suggests that the trusts of Camorra Limestone Mining Company Limited has not been investing the PF Money Trust as per the pattern of investment declared, laid down by the Government of India and notified by the Employees Provident Fund organization. This is in violation of the said Government of India notification. Therefore, you are directed to show cause within 14 days from the date of receipt of this notice as to why the exemption granted under section 17(1)(a) of the Act 1952 should not be withdrawn from your trust for violating the terms and condition of exemption, as well as recovery of surcharge from the Board of Trustees for failure to make investment as per the direction of the government in terms of condition under section 17, failing which the said exemption shall be withdrawn without any further notice. Lordship, now if we come to Annexure 4, page 33, Lordship, here they have replied. Clause A, Lordship. Yes. As far as practicable, we have tried to invest the trust money as per the investment pattern notified by the EPFO. However, we are unable to adhere the pattern of investment as availability of investment opportunity is frequent. In order to make up for the lack of investment opportunities, we have restored to invest in whatever investment that are readily available. We are to inform you that our organization is a very small organization and our monthly contribution is also very mere. We are not in a position to invest the trust fund at the given time frame. However, in spite of above difficulties faced by us, we have taken serious note of the investment pattern as laid down, and we will make every effort in the future invest according to the pattern specified in the specified by the concerned authority. Lordship, this here in 2009, up to 2009, they have not invested the money. According to notification, Lordship, they are supposed to invest because the clauses states that if they are failing to fulfill the clauses, their exemption is liable to be cancelled. Now next page, page number 34. We are, however, considering surrender of our exemption. So now in 2009 itself, they have surrendered the exemption.
Considering or surrendered? They have surrendered thereafter.
However, considering surrender our exemption, kindly let us know the formalities. So as part the formalities, they have already surrendered. Thereafter, they have made all the payments which we have annexed in our affidavit, Lordship, which my learned friend also have stated that they have surrendered their exemption and they have continued with their payments. Now, Lordship, in as per the order, Lordship, as per the order, page number 46 of the order, we have given them for the period of the damages we have calculated. Page number 46.
Yes.
Damages and the interest laid on. So damages is from 14/4/2016 to 11/2016. Total comes.
Yes. Page 46 is your notice of demand.
Notice of demand. Page 46 is the notice of demand, and wherein we have clearly indicated what is the damage and what is the interest.
Yes. Nine 6/2019.
Yes. 4/2016 to 11/2016.
Is it 2000? Is it 2019 or 2017?
2016, Lordship, I think. Yes,
9/6.
The notice of demand is dated 9/6/2017.
2000. You have given me this one, no?
There are two writ petitions. Which one are you referring to?
2016? No. Writ petition only.
So this page 46 here is 2017.
I think there is some.
Annexure 2.
I think because there are
Annexure
two
11.
writ petitions, Your Lordship. One is 183, one is 184.
Yeah, two writ petition.
There are two writ petitions. I think they are along with the one. We are going through 183, right? Page 47. There is some mistakes in the pagination, Lordship. I think page
Whatever the case, just read out.
Yes, Lordship. Now we have already given them the what is the amount of interest.
Just read out.
Yes.
What is it? Please take notice of that certificate case. So is it so?
Pardon, Lordship.
What are you reading?
Page 47. This office of the recovery officer from the page 47. Yes, details of the amount mentioned in the recovery certificate issued by the authorized officer. This is for the for writ petition 83, and for writ petition 84 is 2016, and for writ petition 83 it is 2014 to 2015. Now they have already, since the surrendering.
No, I think this is wrong. You are reading the.
For WPC 80.
Okay, yeah. So in page 47, it's details of amount mentioned in the recovery certificate issued by. Okay.
This is period is from March 2014 to.
What is the? Yes.
Page number 47, only last column.
What is the total?
It's last column.
Okay, just read out the total.
Period.
Okay.
Period. I'm going through the period. I'm not going through the total. I'm going through the period.
2000. 3 to?
2003, no, Lordship, March 2014.
Okay, March 2014.
March 2014 to June 2015.
Okay.
The down, there down it is the total, Lordship.
This is.
And a little bit difference is with 84 is same only, but 84 damage is, the period is 2016. In the petition 183, period is March 2014 to June 2015, and read petition 84, it's 2016.
Yes. You have not mentioned anything about writ petition 184, Mr. Thava?
Lordship, it's only the period.
It's only the period.
No, but you should have, in course of your submission, you should have made a mention that you are making a joint submission with both.
Because they were tagged along together. Both the writ petitions were tagged along some time back.
Okay.
It is only regarding the period, Your Lordship.
Yes, please continue.
So now the period is 2014 to 2015, and into writ petition 184, it's 2016. So, Lordship, they have already surrendered. They have already surrendered in the year 2009. So, since they have already surrendered 2009, thereafter, and also the notification, according to the clauses of the notification, they could not comply. So, they have, further they have surrendered, and since they have continued to deposit their dues, so obviously they comes under the preview of the Employees Provident Fund. Their exemption is, though they were exempted, but since not following the clauses of an exemption, they are treated to be an unexempted organization. Now, Lordship, I have already given the copy of Supreme Court judgment, Lordship, 2012 to SSC 489, Lordship. I have already in
2012
to SSC 489, Lordship. It might be in the record, Lordship. Para number 11 para is 56, 57 and 58. Lordship, I have given the copy of the judgment.
Yes, sir, have a look.
The judgment.
Have you given the list of date earlier?
Lordship, I have already given, but I have only one copy now presently. Lordship, you can refer. I have marked here. Lordship. I have only one copy.
No, I don't think it's here.
Lordship, I cannot remember, but in the
last
paragraph, Lordship, last paragraph, the last page, Lordship, you can turn the last page. The relevant paragraph I have marked already. Lordship, I'll supply my copy only, Lordship, this one. Relevant paragraph is 56. High Court's interpretation also was in error for not considering another well-settled principle of interpretation. It is not uncommon to find legislatures sometimes using word by way of abundant caution to find out whether the words are used by way of abundant caution. The entire scheme of the act is to be considered at the time of interpretation. In this connection, we may remember the observation of Lord Reid in IR Commissioner versus Dawal O. Mohane and Co. reported in 1952 at page 537, wherein learned Lord said that it is not uncommon to find the legislature is inserting superfluous provision under the influence of what may be abundant caution. The same principle has been accepted by this court in many cases. The High Court, by adopting, if we may so at rather straitjacket formula in the interpretation of the expression so far as may be, has in our judgment misinterpreted the intent and the scope of the purpose of the act. For the reason aforesaid, we are not inclined to accept the interpretation of the High Court, and we are constrained to overrule the judgment of the single bench as also the division bench. We hold that in case of default by the employer by an exempted establishment in making its contribution to the Provident Fund 14B of the Act will be applicable. Lordship, I'll...
Yes, sir. Sure.
It's here. Lordship, according to this judgment, if it is exempted also, then exempted establishment also is liable to pay the EPF dues under section 14B.
Yes.
The further, Lordship, the section 17, Lordship, I'll come to section 17A. Section 17, clause 1, small a.
Yes.
Where an exemption to be granted. Okay. Lordship, the provision of section 6, 7A, 8 and 14B shall, so far as may be, apply to the employer of an exempted establishment in addition to such other condition as may be specified in the notification, which is specified in the notification, Lordship. Then, according to the notification, what I have mentioned, granting such exemption, and wherein such employer contravenes or makes default in complying with any of the said provision in condition to the condition or any other provision of this act, he shall be punishable under section 14 as may if the said establishment has not been exempted under the clause. So it may be treated as, if they are not following the clauses, Lordship, they will be treated as an unexempted establishment, Lordship. That's all, Lordship, for my
Yes.
And most of it has been covered by my friend. Lord, as far as the state notification is concerned, my lord, now initially, my lord, the state had not filed any affidavit in opposition in this case, because, my lord, primarily the contesting parties were the Provident Fund and the petitioner herein, my lord. But subsequently, my lord, when the matter of clarification with regard to, my lord, whether the exemption is there or not there, my lord. So subsequently the government came out with a notification dated, my lord, which is dated, my lord, 20th November 2019. So, my lord, this notification says that, my lord, the exemption stands withdrawn, my lord. Now, as far as the power, whether the government has the issue, my lord,
But have you that notification comes subsequently to the after the filing of this petition?
My lord, during the pendency.
Have you brought that on record?
Yes, my lord. And an affidavit was filed just to bring on record the notification, my lord.
Was that affidavit,
it's part of the record, my lord.
Was it responded to by the prisoner?
This was just to bring on record. I am not sure whether he responded to that, my lord.
It was just to bring on record the notification.
Maybe,
but we did not file any.
See, if it is brought on record, but it would have a bearing on the case.
Yes.
Because now, being part of the pleadings, the court can take cognizance of it. So that would affect your case. If you had not taken, you have not filed any rejoinder to the same, it means we have accepted the situation as it is.
To this we have not filed.
That is the law of pleadings.
Because we had filed our rejoinder, Your Lordship, since the...
No, my lord, the rejoinder was to the affidavit which is filed by the Provident Fund.
Yes, that is true. But now we are talking about the introduction of the new facts by the state. So, Mr. Thaba, you consider it carefully because otherwise your case will hinge on that.
Yes, Your Lordship.
How about, my lord, they have...
Where is your Mr.?
My lord, the notification, this affidavit was filed dated 20/2/2020, my lord. This is an affidavit in compliance with the Honorable Court's direction dated 9/12/2019. My lord, the notification is enclosed at Annexure A, page 4 of the affidavit, my lord.
Yes.
My lord has found this.
Yes, it's here.
So, my lord, in the notification, if I may read, my lord, what it says. Whereas the inspection report dated 24/9/2008 by the Compliance Audit Inspection Team revealed that the trust of Messrs. KLMC Limited has not been investing the Provident Fund trust money as per the pattern of investment laid down by the Government of India and notified by the Employees Provident Fund organization, and hence violated the said Government of India's notification. So, my lord, this very notification refers, my lord, to the compliance audit which had, my lord, taken place way back in the year 2008, my lord. So, no doubt this is a formal order, my lord. This notification is a formal order. Now, whether the government has the power, my lord, my learned friend has already admitted to the fact, my lord, because my friend had drawn the attention of this Honorable Court of Section 17(4) of the Provident Fund Act, my lord. So I may be allowed to read it again, my lord. My lord, what it says.
Yes.
Or subclause 4, my lord, subsection 4. Any exemption granted under this section may be cancelled by the authority which granted it by order in writing if the employer fails to comply. So there are the certain conditions, my lord. So, my lord, whether the state government had the authority to issue this notification, there is no doubt, my lord. The state has the power, and that was admitted by my learned friend also. And so accordingly, my lord, this notification came into being, whereby the state has, this is of course, this is a formal order, my lord. Prior to that, there is no formal order as such. So by this order, my lord, the notification stands withdrawn. Now, as far as
withdrawn since,
my lord, the last part of the order, if I am allowed to read, my lord, of the said notification.
Yes.
Now, therefore, in exercise of the powers conferred by Clause A of subsection 4 of Section 17 of the said Act, the state government hereby withdraws. So it says hereby, my lord, hereby withdraws the exemption granted wide letter dated so and so 17/1/2003.
Yes.
So this is the language of the notification.
It was done retrospectively.
No, Your Lordship. Not from the date of the thing of the notification was issued.
Yes, you see, exemption was issued to you in 2003.
Yes.
17/1/2003.
17/1/2003.
So now by this notification, the same was withdrawn, exemption was withdrawn with effect from the same date. Isn't it so?
Yeah, Lordship, here it's
Yes,
doesn't
withdraws so it's not
here
retrospectively.
hereby withdraws
True.
It says
Not
prospectively, not retro.
prospectively.
It says hereby withdraws. So as far as the power is concerned, whether the state had any power to issue, my lord, yes. Now as far as my lord, the very basic idea of, my lord, the exemption was that the trust money, that provident fund trust money, my lord, would be invested in some better avenues, my lord. Now admittedly, my lord, in the writ petition itself, the petitioner company has admitted also that they are unable to invest the money in better schemes, my lord.
Yes.
So because end of the day it is for the benefit of the employees, my lord. And my lord, the very clause also states, my lord, my lord, the end, if I refer to, my lord, this annexure 2 of the writ petition, so I am referring to the typed copy, my lord, which was supplied subsequently.
Yes.
So, my lord, clause 29 is very clear, my lord. My friend has read the other parts of the clause, my lord. So here also it says,
Clause 29.
yes, my lord. The exemption is liable to be cancelled for violation of any of the above conditions. So, my lord, even if there is a violation of any one of the conditions also, the exemption can be cancelled, my lord.
But you see, if it is to be cancelled,
My lord.
then a process has to be followed.
My lord.
Was that process followed?
Yes, my lord. Its order is issued in fact, my lord, will kindly see in the writ petition itself, they have admitted that they are unable to invest the money
That
as
is
per the
fair.
directions of the government, and they also have admitted to the fact that they are considering to surrender. Now, of course, that is between the petitioner and the provident fund, my lord. Now, the section 17(4), what it says, my lord? If I'm just reading it once again, my lord. Any exemption granted under this section may be cancelled by the authority which granted it. So I was the authority which granted the exemption. Now I am the same authority who's cancelled it. So the question of competence
Yes.
cannot be raised, my lord. By order in writing. So there is an order, a notification which has come.
So that is in the year 2019.
2019. If an employer fails to comply, so there are the conditions which the employer failed to comply, and hence this notification came into existence. Whereby exemption earlier granted had been withdrawn. So that is the case. And my lord, I will again refer to now another this section 17, where my lord, again 1A is again clear. 1A subclause A, that small a, my lord, there also it is very clear that if the conditions are not met, it may be treated that as if there was no exemption granted. That is also said. I am reading it once again, my lord, just for my lord clarity, my lord. The provisions of section 6, 7A, 8 and 14B shall, so far as may be, apply to the employer of the exempted establishment in addition to such other conditions as may be specified in the notification granting such exemptions.
You're reading?
So, my lord, this I am referring to section 17, where it says power to exempt, my lord.
1A or 1B?
I am referring to 1A, my lord.
Small a?
1A, and then under that is a small a, my lord.
So
this will be page 40, my lord.
1A, capital A.
Yes, my lord.
Yes.
And subsection A, that small a, my lord,
Yes,
which follows. The provisions of section 6, 7A, 8 and 14B shall, so far as may be, apply to the employer of the exempted establishments in addition to such other conditions as may be specified in the notification granting such exemption. That means apart from whatever is stipulated in the notification, my lord, this is in addition to that, this clause applies, my lord. And where such employer contravenes or makes default, so my lord, there is a question of default, in complying with any of the said provisions or conditions or any other provision of this act, he shall be punishable under section 14 as if the said establishment had not been exempted under the said clause. So there is a rider, my lord. So as far as my submission, my lord, I raise my submission here, my lord.
I have one point raised by my learned friend, which with regard to the who is because of the EPF issuing notice, the employees are sufferer. Lordship, once we have issued notice to collect the damages, it's for the employees, Lordship, because the contribution were deducted, they were not depositing. So for the betterment of the employees, the sufferer, it's because in 2017 only this case was filed. Now it's 22. They have obtained the stay order, which is in continuation. So once there is a stay order, there cannot be any operation in the case. So obviously, who will suffer? The employee will be sufferer. For that case, we are not the responsible authority because we are the caretaker of the employees. And also the trustees are liable, Lordship.
Lordship, just small point, Your Lordship, that stay order was regarding the order whereby the penalty was imposed and the notice of recovery, nothing else.
But in the meantime, are you still contributing or you have stopped contributing?
At present, as I had submitted earlier, Lordship, the entire operation of the petitioner company has been suspended by IBM for several past.
So what happens to the employees then?
Lordship,
what is their fate now?
At present, Your Lordship, we cannot even pay the salary because almost 3 years now the mines have been shut. There's some other problem. But regarding this particular case, Your Lordship, that order which was passed initially when the writ was, that order has got nothing to do with the benefits of the employees. And regarding the point raised by my learned friend in regarding section 7I, which is appeals to tribunals, Lordship,
yes,
this states that any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the proviso to subsection 3 so and so, except an order rejecting an application of review, may be review referred to in subsection 5 thereof or section 7C, or may prefer an appeal to a tribunal against such notification or order. But now, Lordship, I have already challenged that the order itself, Lordship, the order itself is not maintained. The person who initiated the proceedings does not have the authority. So how can we appeal when the proceedings, the whole proceedings are all vitiated? And regarding the notification, Your Lordship, this notification by which the exemption has been cancelled has been challenged in WPC number 118 of 22. So it is still pending adjudication. It is not a final.
No, that is a different thing. That's a different thing.
Whatever my learned friend has submitted regarding the appeal part, it is also a case, Lordship, where they have not come not filed the appeal on time, and they have taken the course of repetition to avoid appeal, to go to CGIT in Guwahati to avoid appeal and come as an alternative course to avoid going there.
You
So,
cannot
Lordship,
just
Lordship,
because
that is
if your lordship just goes through annexure 11, the last part, page 46, last part. You are informed that in case of default, steps would be taken to realize the amount in accordance with provisions of section 8b to 8g of the EPF Act by one of the modes mentioned below. A. Attachment and sale of the movable or immovable property of the establishment, or as the case may be, the employer. Number B, next page, Your Honor. Arrest of the employer and his detention in prison. So, Your Lordship, these are the 2 points due to which we had to come before Your Lordship by this writ petition. There was an urgency.
So parties have been heard. Have you filed your written argument?
no, Lordship.
We have not filed. Mr. Thava?
No.
It would be better if you file a written argument. Short synopsis, bullet point. And like this court used to maintain, if you have any authorities to support your argument, you can do it. How long will it take?
3 weeks, Your Lordship.
Let it come after 3 weeks, Lordship.
But if say 3 weeks, then let it be within 3 weeks.
Yes, Lordship.
I don't want to extend beyond that.
Lordship.
As it is, the matter is already a very old one.
Yes, Your Lordship, because it was heard earlier and it has to be reheard. The whole thing had to be reheard today.
That's exactly the point.
Earlier, the only problem was that during the course of the hearing, this notification.
Oh, that not legible.
Yes.
Parties have been heard in this matter, and on conclusion of the oral argument, submission has been made that the written argument or synopsis of the oral argument may be allowed to be filed. As prayed for, this is matter after 3 weeks.
Item number 20.
Highly obliged.
Yes, Mr. Thank you.
Please, Your Lordship. My Lord, this is a case regarding the appointment of one disabled person, my Lord, specially able. My Lord. In the last occasion, Your Lordship had posed a query whether the private respondent was still in service or not, my Lord. It was for the government's part to reply, my Lord. Whether the private respondent who had been illegally appointed, my Lord, is still in service or not, my Lord. To that limited extent, my Lord.
That has been answered, I think.
There is no stay order also.
There was no stay order.
There is no stay
No, my Lord. But then one of our prayers, my Lord, was that to quash the appointment, the illegal appointment of the private respondent.
That will come at this stage when the matter is to be heard finally.
My Lord.
Otherwise, even if the private respondent, even if he's in service or not, or still continuing, makes no difference now.
Makes no difference.
My Lord, because it makes a small difference, my Lord, because they had said that certain advertisements had been floated. They have portrayed before this court that a level playing ground had been created. Now, my Lord, if he's still in service, where's the question of a level playing ground? Lord, with me.
The issue of floating of the advertisement
My Lord.
has come subsequently.
My Lord.
That is a recent development.
My Lord.
So in the light of that, perhaps the respondents should have taken steps, but if they have not, the matter will be dealt with accordingly.
Exactly. This court has adequate powers to deal with them adequately.
So what do we do?
Lordship,
We hear the matter?
As your Lordship pleases.
Lordship, in this matter, the department had issued the advertisement, and Lordship, the department has not yet conducted the selection, because Lordship, the preparation of the roster is in the process. So,
have you filed any additional affidavit to that extent?
we have filed an affidavit to bring on record your advertisement.
No, not a detailed one. It's just a statement that has been made, not a detailed one.
Yes,
Nothing
your
concrete.
Your Lordship also had inquired on the last day.
In fact, the filing of such things, if I may say,
Status of the appointment of the teachers. But the advertisement has been issued, but selection is yet to be done. It's yet to be conducted. In view of that,
we are not in the process of selection now.
Lord, may they be directed to put before the court on record, Lord, the advertisements that have been floated, the number of posts that have been put forward.
we have already done.
That has already been done.
I don't find them in my annexes, Lord. Or maybe they have. I don't find them that. Lord. I don't find them in my.
You should have received a copy of it.
I received a copy, but no annexes at all, Lord. Nothing at all, Lord.
No, Lordship, I have given them the
No, let us.
affidavit.
I don't have that with me, Lord.
15.9. Is it 15.9, Mr. Harmi? Is it 15.9?
Yes, I have filed it.
You filed it on 15.9?
Yes, I think you can.
Just check your.
I'm done copying it.
No.
I'm done. 15.9. Maybe, sorry.
When did you file your business?
He's going to get his
File, madam. He's going to.
I think, Mr. Thank you.
My lord.
Actually, it would be this affidavit filed on 15/6, I think, 2022.
I don't have that.
Yes. So, copy of the advertisement has been placed
on record.
On record, and let's have a look.
Affidavit is 15 June.
Yes.
15 June.
Oh,
2022.
Yes, all these annexes are there, Mr.
Yes.
Sorry, my lord. It was given to one of the colleagues of the senior counsel. My lord. It was not in my brief. My lord. I apologize for that. My lord.
So we'll take up this matter after lunch. Mr. Thank you.
My lord, if your lordship is kind enough, my lord, to grant me some time, I'll just go through this, my lord. I was not aware that this was in existence, my lord. Accordingly, I came prepared with that, my lord.
Came prepared to bamboo them on that.
No, my lord. On other things, my lord. On other things, my lord. But now that this has come to light, maybe there are other things that I can maybe
I think
try
we
to.
even annex all the details with regard to the roster.
Yes.
Right, my lord. The roster is just one of the points, my lord.
We have,
that has
next,
crept
we
up.
have filed this long time back, and it is very surprising that my learned friend is not aware.
15/6.
Assisting the senior counsel, but
15/6,
he's not aware of this
2022.
affidavit.
Fine. Anyway, when do you want it to be done?
Lord, if your lordship is kind enough to have it after 2 weeks, my lord.
on prayer made by the petitioner, this matter up to 2 weeks.
Obliged.
Much obliged, man.
Item number 21.
Cakap beli dong, man. Adik-adik soal tu koi. Oh, tu koi.
Your Lordship, last occasion, this actually there is possibility that party may file for this compounding. This was there. So yesterday I confirmed from this ROC. So Your Lordship, ROC actually out of session. So I was not prepared today. So accordingly I was informed. So if can it be accommodated for few days?
On the last occasion also said that, my lord, that there is a proposal. I inquired, there is no such proposal, my lord.
Mr. Devnath has submitted that perhaps the competent officer or the relevant authority has not been able to communicate to him the instructions.
No, but I can understand, my lord, but on the last occasion also he said that, my lord, there is a proposal for composition. I inquired from the client, there is no such proposal.
So Lordship, this information was given to me earlier. That there is a
you file a
Mr. Devnath, you get specific instructions.
So,
And if there are any
no written is given verbally, they came in.
That's what you see. Nothing can be done verbally in court.
So Lordship,
You have to affirm your stand on evidence, on documentary proof. So if you have to get instruction, relevant order or notification or whatever, you file it in court. At least the other side should not be taken by surprise. They should be informed because it involves their interests. So if you say this court has indulged you to that extent, saying that since you wish to seek instruction,
then in the next day, Your Lordship, I will be hearing, Your Lordship. Because yesterday also I just communicated to this Dr. Saraf's chamber that this is the matter. So I didn't have anything, so I may take time. So in the morning I says, okay, I'll not mention first of all when matter will come up, then I'll explain. Because earlier this communication was that may be wrong, then ROC I was not in a position to contact. He is in hometown. I was not getting him by over phone also. And earlier it is given when last occasion ROC says if anybody says okay, all right, let me think about it. So this due to this I make a submission. It is not my intention that's to delay the matter, Your Lordship.
ROC is taking the court very lightly because there's so many times, my lord, the way the things are going on. I will not object to it, my lord. Your Lordship will fix up a next date, my lord. On that date, either the things will be over or the matter may be heard.
please do that. How long?
It kept 3 weeks, Your Lordship.
3 weeks. But no more adjournment. Either you get your instruction or we finish the matter.
Yes.
They are very poor case, my lord. That's why they are running away. Every time they are running.
In any case,
that depends.
If it is coming up for the compounding matters, then it is matter ends. And if it is not,
depends on who can convince the court better, either you or Mr. Devnath.
Well, somebody who is always taking time.
When this our senior counsel has come, definitely there will be some case, definitely. But I believe that 202 is what's called raised. It is not applicable in this case. So I am very much confident that 202 CRPC will not be applicable in this case. But still, my senior counsel is yes.
I am saying to ROC that ROC always taking time and time. That also gives some hint that they have no case.
Mr. Devnath, you should impress upon them. You see, it's like Dr. Sarava said, it's a court matter. If they don't take the matter seriously, then it will be either negative inference can be drawn or whatever. Anyway, that's beside the point. Mr. R. Devnath, Leonard CGC has once again sought accommodation in this matter, in as much as it is submitted that specific instructions from the Register of Companies under bracket ROC has not yet been received, which will have a direct bearing in as far as this matter is concerned. It is therefore prayed that this matter may be taken up after 3 weeks. Leonard Senior counsel appearing for the petitioner has no objection to the same. Pray aloud. List this matter to 3 weeks.
Actually, Your Lordship, I just about it. Because of it, Your Lordship, if suppose component applications come up and I hear the matters, then suppose there any order pass, then it will be without permission of this court and it will be another problem. Because matter is pending and stays.
Compounding application has to be filed by the petitioner and then only it will become. So we will not file it.
Yes.
My Lordship object. My Lordship.
Your Lordship,
because that you see even
Your Lordship, here, if the petitioner filed the component application, we are not preventing. So when inquiry questions come up, then it is my responsibility to say. And if suppose they file the application and I heard the matters here and I didn't inform to the court, suppose execution pass and given relief to them. So then what shall I
We have not filed. We have not filed. If you file it, we inform the court. My Lordship, object that in case the
sometimes
no
you listen.
instructions
I may be.
but Dr. Saraf, if feelers have been sent to you, that the matter can be compounded. It's to your benefit.
You listen, I find even sometimes.
My lord, feelers may be sent, but that unless and until that, my lord, feelers, as your Lordship knows, without anything concrete, feelers may come anything. That has no meaning, my lord.
Your Lordship, I have attended so many cases, even ROC matters. I find
that is a submission in court. It has been noted down in the order. So,
Your Lordship, last question I find.
Take notice of that.
Your Lordship, last question I find.
In case on the next date, my lord, there is nothing, then matter will be heard.
Yeah, exactly. That's what has been noted.
Your Lordship, here,
my
senior counsel is here. It has happened in the court. Your Lordship, in the court, I have taken the step, and after that, fine was imposed. And subsequently, I came to know on the very next day that compounding order and another was passed, and then they sent to me the copy. Then questions come up, and this already they make payment to the court, and another matter has come up from the compounding. Then problem was.
Yes, Mr. Devannath, in case you file a compounding petition, we will first inform the court. Don't equate everybody.
Yes, this when I got the verbal communication, it was my responsibility, and I thought maybe there is some communication gap. So that's why this I just mentioned. It was not my intention. Because somebody is informed to me, not ROC, but some officer that there is a possibility here.
I'm not at all saying. I'm not at all saying intention of yours. I'm not.
I should not talk to my even ROC too, because that's why I was speaking.
Yes,
Mr. Devannath is very well. Is very frank. There is nothing like that. His intentions are. I never said. I only said about the ROC. Madam.
Exactly. Fine. Thank you. Thank you.
Item number 30.
Second half I had some difficulty with it. It's kindly listed after 2 weeks.
The second half, it seems you're always going. Huh?
Problem is, my lord, I have school duty actually.
School duty.
Same problem in that. But big cream also having, so with the permission, he left.
Because there itself, my lord, 1 hour easily goes away, my lord. 1 hour, 1.5 hours.
In fact, this case, the parties have already, in fact, it was 2021, matter was heard orally. Then we file our written submission. All the parties have filed their respective written submission. It's only we just want to refresh the matter again.
So how, when do we take it up?
After 2 weeks, my lord.
2 weeks, not except 28. 2/8. Lordship, I will be out of station on 2/8.
It may come in first week of May also, my lord.
1st of May also.
First week or second.
After 2 weeks.
After 2 weeks.
On preliminary with the parties, this matter up to 2 weeks.